All right, welcome to the Environmental Law Institute. My name is Caitlin McCarthy, and I'm the Director of the Associates Program here at ELI. You who have joined us for NEPA, ESA, and Fundamentals in Environmental Law, part of ELI's annual summer school series. We're delighted to welcome everyone here today, in person and online, and I encourage you to follow the events page on our website, eli.org, for future events and the next summer school seminars. For our audience members on GoToWebinar, we encourage you to ask a question by submitting it through GoTo's question box. Please send them as soon as you think of them. Do not wait to the end. For our audience in the room, please take a microphone for questions during Q&A. I'd like to thank our wonderful panel for being here with us today to teach the National Environmental Policy Act, Endangered Species Act, and the fundamentals of environmental law. A recording and PowerPoints of today's seminar will be available on our website within the next week. So the full speaker bios are posted on our website, eli.org, but I would like to take a moment to introduce our outstanding panel. Nikki Adame-Winningham has joined us from New York City, where she is Corporate Counsel in the Environmental Law Group Legal Division at Pfizer. Nikki has years of hands-on experience involving environmental transactional support, regulatory compliance, and litigation support related to air, water, waste, and site remediation issues. She previously spent over a decade in private practice, and before that was a Congressional Hispanic Caucus Institute Fellow with the EPA and interned with the Texas Commission on Environmental Quality. She has undergraduate and graduate training as an environmental engineer at Cornell University, which allows her to understand the technical as well as regulatory requirements of environmental compliance. Nikki received her JD from Tulane University Law School and is involved with the New York State Bar Association, Hispanic National Bar Association, and the Cornell Alumni Ambassador Admissions Network. Thank you for joining us, Nikki. Jane Davenport is a senior staff attorney with Defenders of Wildlife, where her litigation and legal advocacy work focuses on protecting marine species from direct and incidental take-in fisheries, and also protecting freshwater aquatic species from habitat destruction and pollution from surface coal mining. Previously, Jane worked for the Delaware Riverkeeper Network, Oceana, and the Ocean Conservancy, where she started her legal career in the Wildlife and Marine Resources section of the Environment and Natural Resources Division of the Department of Justice. Another Cornell grad, Jane received an AB and MA in Government and East Asia Studies from Cornell University. She also earned a Master's of Environmental Studies from the Yale School of Forestry and Environmental Studies, and her JD from Yale Law School. Welcome, Jane. Margaret Hill has joined us from Philadelphia. Peg has been practicing environmental law for more than 30 years and chairs Blank Rome's Energy and Environmental Practice Group as partner. Peg's multifaceted background and experiences encompasses work for a large energy company, as a trial attorney for the Department of Justice's Environmental and Natural Resources Division, as a lobbyist before Congress, and in private practice counseling clients with respect to state and federal environmental laws in litigation, compliance, and transactional matters. Her expertise includes court arguments, complex environmental enforcement defense actions, corporate internal investigations related to all environmental law violations, defense and cleanup and remedial actions, managing environmental due diligence and negotiation in transactions, and environmental counseling for companies and institutions on a day-to-day business matters. She received her BA cum laude from Westchester University, a master's magna cum laude from Northeastern University, and her JD from Duque University School of Law. Glad you could join us, Peg. So with that, I will turn things over to Peg to start us out today.
Thank you, Caitlin. It's like yours is first.
No, that's not mine. That's keep going. Do we need to?
Oh, there we go.
Down.
Oh,
There you go.
all right. Okay. I'm a lawyer, but I can't handle a clicker. Good afternoon to everybody. Before we came in today, we were chatting among ourselves, and one of the things that Nikki was saying, be good to have some understanding of who's in the audience. So just wanted to get an idea for those of you who are sitting here in front of us, how many of you have any exposure to environmental law? Okay, so it looks like quite a few. All right. Well, our program today is really designed to give you some of the basic understanding of the important environmental statutes, the federal environmental statutes. Of course, there's a lot of state statutes as well. I'm going to start out. I have a lot to cover in a very brief period of time, and there is information in PowerPoints, but pretty much I'm just going to be talking to you from some notes that I have from some old PowerPoints about some of the major and federal environmental statutes. But I was going to start out with just kind of a brief overview of administrative law. Administrative law, for those of you who do not have any background in that area, is really, really important to understanding the whys and hows of environmental law and how you might, review, analyze, and practice environmental law as an attorney. And that's because everything that you're going to be using or working with as an environmental attorney is going to be based in part on regulations and policies and guidance documents that all come from the federal environmental statutes that were passed by Congress. And of course, within the statutes, you'll have basic principles of law that Congress has enacted, but it will instruct EPA through the administrator to propose rules and to finalize those rules to implement what the statute is intended to do. So it's really, really important just to make sure that you have some fundamental understanding of administrative law and how it works, and also with respect to if there's a challenge to a rule, what you will need to do in order to challenge a rule before a court, whether or not there's been a proper delegation of authority, whether a rule has been properly proposed and implemented, what is the standard of review with respect to a particular rule. Is it going to be de novo review by a court, or is it going to be a limited review based on the administrative record? So those are all just important concepts to keep in mind with respect to the practice of environmental law. I'm not going to get deep into that because I would like to talk about the major federal environmental statutes, because there are a number of statutes that are very important for you to know. But you can take a look at this slide in your spare time and look at some of these statutes if you want to, in terms of some of the laws that are relevant to administrative law and practicing environmental law. And of course, I just talked about rulemaking. There's also what we refer to as environmental lawyers as informal rulemaking, where you'll see EPA, for example, put out a policy or a guidance document or some interpretive rule. Those are always really, really important to understand, in addition to the established rules which are set forth in the CFR. So you need to be really familiar with not only rules that are in the CFR, but all the policy guidance, the principles. For example, if I'm handling a Clean Water Act enforcement matter, I would go to EPA's Clean Water Act civil penalty policy to make sure I understood how EPA is reviewing the statute and how they're proposing to identify or come up with the fines for a client that I might be representing. What are the factors that they're going to consider? So all that's going to be laid out in their civil penalty policy under the Clean Water Act. So that's just an example of a policy document that you would need to look to, in addition to understanding what the statute says about the imposition of penalties under the Clean Water Act. And one of the things that I always tell young lawyers is you can never forget the Federal Register, because the Federal Register, even after you've looked at a rule in the CFR, the Federal Register provides volumes of important information in the preambles to the rules, whether they're proposed rules or whether they're final rules. So many, many times I'll have an associate come in and say, well, I'm having a hard time understanding this rule or what EPA meant or what they intended. And usually I will say, go to the Federal Register and look at the preamble, because there's just volumes of information, as I said. So just keep that in mind as you're practicing environmental law. Going too far. Now, there are a number of federal environmental statutes. We're only going to talk about 4 here today because I only have enough time to talk about 4, and that's at a 10,000-foot level. But for practicing environmental law, you really need to know about the following statutes: the Clean Water Act, the Clean Air Act, RCRA, or what's known as the Resource Conservation and Recovery Act, and as that act was amended by the Hazardous and Solid Waste Amendments Act in 1984, or HSWA. CERCLA, which is Superfund. TSCA, the Toxic Substances Control Act, and of course that was just amended back in 2016. Also FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. NEPA, the National Environmental Policy Act, and then ESA, or the Endangered Species Act. And the other thing you need to know as environmental lawyer is you're going to learn a lot of acronyms. And that just goes with the program. So keep that in mind. That those are the federal environmental statutes. And one of the things that I have up here is a separate slide, but I'll just talk about it now, is the federal environmental statutes, for the most part, have been delegated to the states to implement and enforce. So every time you might be handed an assignment as an environmental attorney about, well, I have this RCRE question, this hazardous waste question, or I have a Clean Water Act question or Clean Air Act question, you are often going to go to a state statutory scheme as well. So the state will typically have its own version, for example, of the Clean Air Act. And I'll just give you a Pennsylvania example. The Pennsylvania example is they have the Air Pollution Control Act. So if I have somebody who has a question about what control equipment they have to have at their plant, or perhaps there's some enforcement issue associated with the plant, not only will I look at Pennsylvania's Air Pollution Control Act, I'll look at the Federal Clean Air Act, and I'll look at the regulations under the Pennsylvania scheme, but I'll also look at the regulations under the federal scheme. And the important thing there is to understand that the delegation of authority by EPA comes with EPA's approval. So that means that they have looked at the state program. As a result of the delegation, they have approved the program. The program has to be as strict as EPA's program in terms of implementing the Clean Air Act, for example, but it can be more strict than the Federal Clean Air Act. So you never have to forget that you're always looking at a concurrent statutory program at the federal and state level whenever you have an environmental problem, for the most part. Okay, there might be some laws, for example, we're going to be talking about NEPA today. National Environmental Policy Act does have some similar state statutes. If you're in California, you're dealing with the California Environmental Quality Act, I think it is. New York has its own version. It's called SECRA, the State Environmental Quality Review Act. Pennsylvania actually has a provision in the Constitution known as the Environmental Rights Amendment. There's no regulations for that, but it's sort of a version of NEPA. So you need to make sure that you look at federal environmental statutes. So we'll just start now with just kind of an overview of the Clean Water Act. And again, just to show of hands, how many people are really familiar with the Clean Water Act? Okay, all right. Okay, gives me some idea. The Clean Water Act was passed in 1972, and basically it's a program that was designed by Congress to ensure that water quality is maintained in the United States. And it establishes, it's a program actually to establish water quality standards at the state level that are going to be implemented so that water resources across the United States, navigable waters of the United States, are protected. So that's really what the Clean Water Act is all about. The Clean Water Act, Section 301, is probably the most important section of the Clean Water Act. And basically what it says is, except as in compliance with the permit, you are not allowed to discharge any pollutants into a navigable waterway in the United States. One of the things we can't get into detail here is there's a lot of debate, and there's always been a lot of debate over navigable waters in the United States in terms of what is a navigable water. So you can always Google all the case law on that, but there's a lot of case law out as to what the navigable waterway is. But essentially, you have to have a permit. And so there's a permit for a discharge into a surface water where you might be discharging. And just envision that you're representing somebody that has a chemical plant, or maybe it's a paper mill or something like that. There's going to be some wastewater that's going to be produced during the manufacturing process. That wastewater most likely is probably going to be initially treated at the facility, and then ultimately it's going to be discharged into a surface water. So before it can be discharged, even with pretreatment at the facility, and there may or may not be pretreatment, it has to be permitted as it enters the facility, leaves the facility, and enters that surface water body. So those are issued under Section 402 of the Clean Water Act. Again, a state program that's typically implemented by EPA, provided there's delegation authority to the state. And that is called the National Pollutant Discharge Elimination System Program, NPDES. And all the states have their own version of NPDES permits. So you have to be familiar with that program. We're going to talk a little bit about that. There's also what's called dredge and fill permits under Section 404 of the Clean Water Act. And those are permits that are issued by the Corps of Engineers with EPA oversight that authorizes a person, and under all the environmental statutes, just take my word for it, person is broadly defined. It includes everything and everybody. So any person that wants to use a dredge and fill permit to fill a wetland or to dredge a water body, you're going to have a 404 permit, again, issued by the Corps of Engineers, but EPA oversight is involved. Okay, we talked about discharge into a navigable waterway. Basically, a discharge is you're adding some pollutant into the waterway. So again, pollutant's broadly defined, person is broadly defined, discharge is broadly defined, and all that you need to look at Section 301 because again, that is the most important part. Do not put a pollutant into a navigable waterway without a permit that's going to be issued by EPA or state. And the pollutant is going to be coming from what we call a point source, which is also defined under the statute. And it's defined as any discernible, confined, and discrete conveyance, including but not limited to any pipe, ditch, channel, tunnel, conduit, well, from which pollutants are or may be discharged. So you're looking for some pollutants going to be discharged from some particular point source. And I always think of a plant just because I do a lot of work with manufacturing facilities. So, for example, with a chemical plant, there's going to be some pipe or a bunch of pipes coming out of that facility that's going to be going into a river or water body somewhere. Now, the NPDES permit program is going to be, for the most part, implemented by the states. So, for example, you're representing chemical plant A. They're going to be discharging some amount of pollutants into the water. You're going to go to the state. You're going to fill out an NPDES application. You're going to identify in the application what exactly you're manufacturing there, what are the chemicals you're using, what are the anticipated pollutants that you think that you're going to be discharging. That permit writer, they will sit there, review the application. They may ask you some questions. They're going to come up with and issue you a draft permit for the facility. And that draft permit is going to include a lot of different things. It's going to address some, what we'll call some general pollutants, biological oxygen demand, total suspended solids, some things like that that you might be discharging into the water body. There may be specific chemicals or toxics that you're discharging. It's going to identify those. And your permit's going to include what we call effluent limitations. So how much BOD or how much total suspended solids can actually go into the waterway. It's going to require you to monitor to make sure that you're compliant with that permit terms in terms of how many total suspended solids or BOD, or what, maybe it's a certain amount of like aluminum that you're discharging or something like that. So there's going to be all these limits and monitoring requirements contained in your permit. There's going to be some general prohibitions in your permit. And that permit is going to be in effect for 5 years unless you need to get that permit modified for whatever reason. But that's going to govern your discharge into the water body by the state. And as I said, EPA does delegate the program. So if EPA has an issue with respect to any NPDES permit, the one thing to remember that's important about all these statutes is EPA always has concurrent authority. So even if you're in a state and the program has been delegated to the state that EPA thinks that there's a concern with that permit, that the state's not properly enforcing the permit, or something may be fairly serious, they will come in and they will exercise concurrent jurisdiction to make sure that the intent of Congress is met. So that's what we call the individual permits, a permit issued to a particular facility for 5 years. And then it's renewed after the 5-year period. Then there's also what's known as general permits. A lot of states have these general permits that they'll write up. Again, I'll go back to Pennsylvania. They might have, for example, GPA 2 or 3 or something like that. It's recognizing that you can have a permit by rule. So provided you as a discharge or meet certain requirements and you're not discharging a lot of pollutants, if you meet the specification in the state regulation or state statute, you might just get a general permit. So everybody can apply for this permit by rule. It's not an individual permit because no individual permit is needed. Also, stormwater permits, very, very important. You have to submit a notice of intent to be covered by a stormwater general permit unless you need an individual permit. So the one thing to remember about the Clean Water Act program is it's not only addressing what we call wastewater, which is coming out from a plant, but there's also stormwater, which is really, really important, although you might not think about it, because stormwater, when it's exiting a facility, let's say it's exiting a chemical plant, or, you know, it might be, depending on what manufacturing facility it might be coming from, there might be things out in the yard that as rain is hitting that yard, and, you know, you're storing things outside, there could be some contamination that could be leaving that facility and going into some ditch, some channel, which ultimately is going into some navigable waterway. So very, very important to make sure that clients do have the stormwater permits. And then clients are supposed to put together stormwater pollution prevention plans that are part of your stormwater pollution permit requirements. So there's a lot going on with stormwater as well. So that's another very, very important part of the Clean Water Act. One of the things to know is that your NPDES permit, this is your individual permit now going directly into a surface water body, is, as I mentioned, there's going to be effluent limitations. So the effluent coming out of the pipe, there's going to be limits on that in terms of how much you can actually discharge into a river, for example. There's going to be technology-based limits. So it's going to be actually based on technology. How clean can you make this water based on the technology you have at the plant? And you're also going to have some water quality-based limitations, because what the EPA wants the states to do, and Congress did in the Clean Water Act, is they want the states to look at the different water bodies in the state and to classify those. Are these high-quality streams, high-quality wetlands? What do you have? How are you classifying this particular water body, and what are the water quality standards that are going to apply to that? And that's all going to tie back to that NPDES, that direct discharge permit. Now, the other thing about the Clean Water Act is that there's, in the CFR, you're going to find, for example, new source performance standards. So there's going to be all these different regulations that might be included in an NPDES permit. New source performance standards, for example, are going to apply to new sources associated with particular industry versus existing sources. So depending on when those new source performance standards were issued, that may or may not govern your facility if you have a new source. If you have an existing source, it may be that these standards apply to your facility based over a period of time, or if you modify your facility in some way, they may be applicable. There's also, and this is another important part of Clean Water Act, there's also indirect dischargers. Indirect dischargers are going directly into what we call publicly operated treatment works for the most part. So when you flush your toilet at home, for those of you who don't have septic, you're going into a POTW. That's where your wastewater is going. Or your sink, you know, when you're using your sink water, that's where it's going to POTW. Well, as you can imagine, it's not just residential users going into a POTW. It's also going to be industrial users. So those industrial users may be treating some of the water on site. They may not be, just like the direct dischargers. But ultimately, they're going to have to get a permit issued by that POTW. And that's under what EPA calls its pre-treatment program. So again, EPA will look to a particular POTW or a particular, actually a state first, and they'll decide whether or not they have a pre-treatment program in place for all the POTWs to make sure that it's consistent with what EPA's regulations are. And they'll either approve it or not approve it. Now, interestingly enough, I'll just go back to Pennsylvania. Pennsylvania, while its NPDES permit program is delegated, the indirect permit program is not. So in Pennsylvania, the pre-treatment program is actually administered by EPA, not by Pennsylvania Department of Environmental Protection. So a POTW, I won't name names, that I represent, they are basically regulated by EPA. So they have their own pre-treatment program. We issue permits out to indirect dischargers, out to industrial users. And that's one of the times, for example, typically I'm usually on the defense side, but when I work for this POTW, I'm actually enforcing sometimes the pre-treatment program against industrial dischargers. So if they're in violation of their industrial pre-treatment program, I will go to them. I will say, well, we're going to have to issue civil penalty because you've, violated your permit X amount of time. And EPA monitors all that. They want to know what we're doing with that pretreatment program. So again, two different sides of Clean Water Act: direct discharge into surface water or indirect discharge into some POTW. And as I said, you've got, the NPDES permits and you've got the stormwater permits. So that's sort of like a general overview of the Clean Water Act. And there's a whole lot of other important sections. I'll just quickly mention that EPA, very importantly, has the anti-degradation policies. It's really important because every single state has an anti-degradation policy. And basically, the states are trying to make sure that their waterways are not degraded in any way below the standard to which they have assigned them, or degraded beyond the current status of that particular waterway. So you'll see that in a lot of states. Also, Section 401 is important to know about. No federal permit or license can issue unless a state certifies compliance with applicable provisions of the Clean Water Act, including water quality standards. So all very important to know. And then, of course, there's enforcement of civil penalties to know about with respect to clean water, and all that's laid out in the statute and the regulations. Okay, next high-level overview I'm going to give you is CERCLA. I'm not following exactly in order, but that basically is Superfund. And probably most of you have heard of Superfund, correct? Okay. And as we all know, or most of us know, Superfund was passed actually very late stage of Congress in 1980. And there are some very confusing aspects of Superfund, but for the most part, what it was designed to do was to clean up sites around the country that were contaminated with hazardous substances, which includes hazardous waste, for example. And there was just a recognition by Congress coming out of some very high-profile cases that you had a lot of dumps and hazardous waste landfills and just a lot of different contaminated areas around the United States. So there was this effort to establish this fund that was going to be basically made up of funds from Congress, also funds contributed by industry that would assist in the cleanup of these old sites. And I would say at least now in the 38 years that it's been around, Superfund has cleaned up a lot of sites. There's still a lot of work out there to be done, but it has cleaned up a lot of sites. But the important thing to know about Superfund, CERCLA, Comprehensive Environmental Response Compensation and Liability Act, is that it's not a fault-based statute. So for anybody that is familiar with criminal law, and you've sat in a criminal law class where your professor says, well, you have to be able to show intent to rob, or intent to burglarize, or intent to steal from somebody, or intent to assault. There's always that thought of intent. Superfund, in terms of case law and how it's being enforced and how it's being implemented, there's no need to establish intent. It's not a fault-based statute, strict liability. So it doesn't matter whether you intended to discharge a hazardous substance and release it into the environment, or you did not intend. You are liable. So liability is triggered by the release or a threat of a release. So it doesn't have to be an actual release. It can be a threat of a release of a hazardous substance from a facility into the environment. The people that are liable under Superfund, you've got current owners or operators who are liable. You've got owners or operators at the time of disposal of the hazardous substance. You have arrangers, which are commonly referred to as generators. So if I'm making a widget and I'm using hazardous substance to make this widget, and I have some hazardous substance I need to dispose of, and I give it to Transporter A, and he takes it off to this landfill, I am a generator because I've actually generated the hazardous substances in the process of my making a widget, and it's going off to a landfill. Now, if there's a release from that landfill and they're looking to identify what we call PRPs, or potentially responsible parties, to take care of the cleanup or to take care of the costs associated with cleaning up that landfill, they're going to come back to the generators, which are the people that basically generated the hazardous substances that went off to a landfill or some disposal site. So those are arrangers or generators. Then you also have transporters, and that's the fourth class. So current owners or operators at the time of disposal, arrangers or generators, and then transporters, persons who transported the hazardous substance to a facility that was selected by the transporter. As I said, it covers hazardous substances generally, but if you look at the definition of hazardous substances in Superfund, and that's 42 USC 9601, there's one of the definitions in there, you will see that there's a lot of hazardous substances. It basically incorporates a lot of the other statutes. So take a look at that. What Congress intended to do was clean up the dirty sites first. So what it did was establish what's called the NPL, or National Priorities List. So there are sites that, for one reason or another, because they present some harm to human health or the environment, have been identified and placed on the NPL. And those are the sites that are considered the worst contaminated sites in the United States. I don't even know how many there are now, but I know a lot of them have been closed out. General cleanup period for a site that's been on the NPL, I can tell you from experience, is anywhere from 20 to 30 years. Okay. There's some defenses to Superfund. As I said, it is strict liability, but the defenses that were identified by Congress is, this is the way I always think of them, act of God, act of war. So if, I don't know, maybe there was a hurricane or there was some release that was caused by the hurricane, then that would be an act of God. Or it might be an act of war. If something happened during the act of war and there was a release, then that would be defense. Or as I call it, somebody else did it. But the somebody else did it is really, really a limited third-party defense. So you have to be careful about that. We're going to talk a little bit about that. There's also some other exemptions, I'll call it, in Superfund. There's a secured creditor exemption, basically lenders who are lending to those who might have Superfund liability, and perhaps the property is used as collateral to make that loan. The lender can protect itself from having Superfund liability from making that loan, even where the property might be collateral, provided it abides by certain principles. And again, look to Superfund for that. But that Congress amended the statute a while ago to make sure that lenders could be protected if they follow certain rules. And that was because a lot of lenders were lending money out using property's collateral. The property was contaminated, and they were concerned that if they foreclose on the property, then, oh my God, they're going to become a responsible party under Superfund and then have to clean up a site. So that's one of the exceptions. And then, as I said, the third party, somebody else did it. The Congress also amended Superfund a little while ago to establish a couple classes of what might fit in that somebody else did it defense. One is where you actually are an innocent landowner, that you had actually no reason to believe that the site was contaminated. You didn't contaminate the site. I can tell you I'm not aware of any innocent landowner cases. There might be one or two out there. I haven't run across it in 34 years. You can also be a bona fide prospective purchaser, and that is where you're actually buying a site. You know it's on Superfund. I have a client now, actually I have two clients now, involved in transactions, getting ready to enter into deals where they're going to be buying sites that are actually on the NPL. Just happens to be part of the transaction. So we're going to try to make sure that we do everything we need to do in terms of being a bona fide prospective purchaser. And what you have to do there is you have to follow certain due diligence requirements. You really have to evaluate the property to understand what the conditions are and make sure you understand what the releases have been, what hazardous substances are on the property, because if you go in and buy that property, while you may not have Superfund liability, in order to ensure you don't get Superfund liability, you have to undertake certain precautions that are laid out in the statutes. For example, you can't exacerbate a known condition. If EPA needs to come onto the site, they need access, or the party cleaning up needs to come on the site and they need access, you have to provide them with access. You may need to take some sort of response action on site if there's some sort of imminent substantial endangerment. So you would have to undertake certain tasks, perhaps as a bona fide prospective purchaser, once you do your due diligence and you know what you're buying into. And then one of the other classifications is the contiguous property owner, where you might be a property owner, you had no release on your site that you caused, didn't do anything, but unfortunately you're living next to a national priorities list site, and that release is now migrating onto your site. So those are within the scheme of somebody else did it. Again, you can be innocent landowner, you can be a bona fide prospective purchaser, knowingly buying a contaminated site, or a contiguous property owner living next to somebody that caused the contamination. CERCLA does talk about apportionment, trying to apportion liability where there's multiple parties. very, very difficult to do for those of you who are going to get involved in Superfund cases. Basically, you're looking at maybe the amount of waste that you might have disposed, what was the toxicity, the amount you disposed of, and Congress actually laid out some factors in the statute that you can look to. But usually you're sitting around, if you're representing a client, with a bunch of other PRPs trying to figure out how do we allocate this liability among ourselves. Maybe it's a $30 million cleanup. How do I know if my share is really 5 million, your share is really 10 million? How do we allocate that? But that's one of the things that happens in Superfund liability cases all the time, and that's why they drag on sometimes for years. The allocation process is very, very, very difficult. Under Superfund, one of the things you should know that if you do need to sue somebody for their share, whatever they might have contributed, there's you can either have a 107, that's 42 USC 9607. So that's a section 107 claim where you're looking actually to recover your costs for cleanup, but you have to prove that your costs were consistent with what we call the National Contingency Plan, which is basically the general plan for cleaning up any Superfund site. It's in the Code of Federal Regulations. I think that's 40 CFR Part 300. So it has to be consistent with the NCP if you're going to recover the cost. And depending on what state you're in, what federal circuit you're in, you may have to be an innocent party. There's a lot of litigation right now over who may actually try to assert a Section 107 cost recovery case versus a Section 113 contribution case. A Section 113 contribution case, and that's 42 USC 9613, that's where a party who may have contributed their share, their fair share of cost, might go against another party to make sure that they contribute their fair share of cost. That's a contribution action versus a cost recovery action. And all these are very alive and well, and that's because, as I said, strict, joint, and several liability. That's another important thing about Superfund. So where you may have contributed maybe certain hazardous substance to the site, if EPA is looking for other parties, they can't find them, maybe they're bankrupt, maybe they're not around, you could actually get tagged with all of that liability. So it is joint and several liability. The other thing about Superfund, as we've talked about, there's response costs, cleanup costs. I want to quickly mention there's short-term costs, removal costs. Think imminent and substantial endangerment. Right now, I'm working on a site where there was a lot of PCB contamination, which unfortunately got on a lot of residents who bought from the developer didn't know, but there was a lot of PCB contamination on those properties. So in any event, in terms of cleaning up that site, EPA went forward with a removal action, which is a short-term removal action. Quick, let's get it cleaned up so these people are safe. Versus a long-term remedial action. A long-term remedial action is where EPA is typically issuing, they're preparing, or the parties are, a remedial investigation. Let's see what's out there. Where is the contamination? Let's investigate this. And then they're coming up with what's called a FS or feasibility study. What do we do to clean up the site? We've got alternative A, B, C, D. That's why it's called a feasibility study. What is really feasible to clean up this site? So that's for a long-term cleanup. So those are under the whole category of what's called response costs. That term's again defined in 9601. So there's short-term removal, long-term remedial. The other category, roughly, of what I'll call costs under Superfund, are what we call NRD, natural resource damages. Completely different from response costs. Basically, that's where the state or EPA or an Indian tribe may come in and evaluate the natural resources that were impacted by the release of hazardous substances. So, for example, in some cases, I'm not going to name the river, but on a case I worked on a couple of years ago on a very large river, there were NRD, natural resource damages. Indian tribes were involved, EPA was involved, and then the state was involved. And everybody was trying to determine what was the impact in terms of the actual damages. And think damages as you would in law school. What are the actual damages that we can collect for with respect to how this river has been impacted? You know, whether or not it might be nobody can fish anymore, nobody can swim there anymore, nobody can use the water there for whatever reason, so more recreational use. So there could be a lot of different types of damages per se, but that's very important under Superfund. One thing real quickly for anybody practicing, in terms of transactions, again, like I said, If you are out there buying property, you do need to conduct due diligence. You have to do what EPA calls all appropriate inquiry, look into the property. ASTM has a standard out there that everybody follows, every environmental consultant in the US and actually abroad as well, in terms of identifying what the conditions are. So you know what the conditions are when you buy a property to make sure that if you can avail yourself of being a bona fide prospective purchaser. Okay. And then one other big thing I'll just say right now that Superfund is a lot of sites are very involved in is vapor intrusion. A lot of states now are very involved in vapor intrusion. Essentially, that's where there's contamination. It has migrated into the soil and groundwater, and essentially the contamination vaporizes in through the ground into homes or into buildings. So it's a very, very big issue now that EPA, as I said, and the states are looking at. One of the things to remember for Superfund, federal level, every single state has its version of Superfund one way or the other. So you're not only looking at state federal Superfund, you're looking at state Superfunds, and a lot of states now have voluntary cleanup programs that you can enter into if you're going to clean up a program on a voluntary basis. It may be that the state's voluntary cleanup program is limited to where you have to actually be an innocent party. You could not have contributed to that site, but you can voluntarily clean it up. Some states, like Pennsylvania again, you could have contributed to that contamination, but you get to enter into what's called Act 2 and clean it up with the Commonwealth overseeing the cleanup. Okay, we'll talk about RCRA, Resource Conservation and Recovery Act, what I'll call the third important federal environmental statute. Basically, this is the statute that governs solid and hazardous waste as well as underground storage tanks. Every state, again, has its own version of RCRA. It's going to have its own underground storage tank program. And RCRA, again, covers underground storage tanks. It does not cover above ground storage tanks. If you have above ground storage tanks, you need to be looking at whether or not the tank is holding a regulated material that might be regulated as a chemical product or hazardous waste, or it might be regulated just by a state program, a state statute. Okay, RCRA most importantly provides for what we call cradle to grave regulation of hazardous waste. Hazardous waste is defined under RCRA and under the regulations. Very, very complicated scheme. I'm going to dumb it down. Basically, in the statute and in the regulations, there's what's known as listed waste and there's what's known as characteristic waste, all of which are hazardous waste. So there are wastes that are identified in RCRA and in the regulation as a list of waste. It might be from a specific type of manufacturing category. It might be from a non-specific manufacturing category. But if it's listed as a waste, it's a hazardous waste. And then you have discarded commercial chemical products. Those are also hazardous waste. Then you also have under RCRA what might be a characteristic waste. So if it's ignitable, if it's corrosive, reactive, or toxicity, depending on the levels for any of those four characteristics, it may be identified as a characteristic hazardous waste. Has to be a solid waste first, and then if it's a solid waste, then you have to make a determination whether or not you have a hazardous waste. And the reason you're doing that, again, if you're a Joe manufacturer, Joe chemical plant, and you're making widgets, and you know that you're generating waste, you have to know whether or not those wastes are hazardous. If they're hazardous, they can only go off to certain facilities, versus if they're non-hazardous solid waste, they might be able to go off to the local municipal landfill. But if they're hazardous, they might have to be treated off-site, disposed of off-site, and stored in a certain way. If you're a generator, you're generating the waste on-site, you have a certain period of time by which you have to keep those, that you can keep those wastes on-site, generally 90 days before you have to make sure those wastes are disposed of off-site. And if you keep the waste longer than those 90 days, again, that's a general requirement for hazardous waste if you're a large quantity generator. If you keep it longer than 90 days, then you're going to have a treatment, storage, and disposal facility permit, a TSD facility you're going to have to be. That's what we call a treatment, storage, and disposal. So you're going to have to be permitted for treatment, storage, or disposal. And that's a very, very complicated process to go through in order to get a TSD permit from EPA. So going back to generators, if you're a generator, you're going to have to characterize your waste, know if it's hazardous. You're going to have an EPA RCRA ID number. So you can manifest that waste, and basically you're filling out a form, you're giving it to some transporter to take off site. You have to fill out that manifest properly to identify your waste so they know exactly what's in there. You're signing on the bottom line as a generator that you're testing that the waste is the following. As I said, you can keep it on site for 90 days. There's container requirements, storage requirements for on site. If you're a TSD facility, if you're actually treating, storing, disposing of all site, you have that permit, then you're going to have to make sure that you go to EPA, fill out the application, become a TSD facility. Again, very complicated. Okay, I'm just going to quickly go just kind of big general themes. Clean Air Act, because we're at the very end, I've run out of time. Clean Air Act, originally, the original statute, 1955, amended 1970. Most important amendments are 1990. Basically, the Clean Air Act is at the federal level, and it was Congress' effort to try to clean up the air in the United States. There have been a lot of major improvements as it was developed. The states also implement their own version of the Clean Air Act, as I said, have their own regulations. EPA has to delegate the Clean Air Act to the states. They have permits that are issued under the Clean Air Act. So if you're any kind of facility, you're going to have to get a permit. Just like the Clean Water Act, think about pollutants. Your permit's going to address your pollutants. What are you actually emitting? There's going to be limits on what you can emit into the air. You might have control equipment that you might have to install, like electrostatic precipitators or scrubbers or something like that, in terms of trying to minimize the pollutants going into the air. So think about that in your permits. The states, they actually implement the Clean Air Act program through SIPs, state implementation plans, which again have to be approved by EPA. And that's really all I'm going to say, because it's much more complicated than that. I don't want to get too much in detail, and I know I'm running out of time. So the only thing I was going to say real quickly was I did have on there at the end slide, and just be aware of this, there are international environmental requirements as well. For those of you who might be doing international work, you should know that there's various statutes out there in terms of different countries. The European Union also has a very complicated set of regulations, so you'll need to familiarize yourself with EU requirements as well as specific country requirements. So I'll turn it over to Jane or Nikki. Okay.
Well, let's see who's up next.
It will be a surprise. Yes.
Okay,
Yeah,
there we go. Right, so I'm going to cover NEPA, and then we'll turn it to Jane to cover the Endangered Species Act. Right. Oh, thank you. Okay. No, that was fine.
Okay.
We're working together.
All right.
All right, so NEPA, the National Environmental Policy Act of 1969. I've given you the statutory and some of the rule sites, and we'll take a step. Actually, I wanted to do another little poll. Who is a college student? And sorry, this is in the room. And law student? Okay, and then like non-student. Awesome. Okay, great. So just a step, I want to cover a few more basics then. For those who haven't been to law school yet, if you're looking for an environmental statute, chances are very good it's going to be in the Title 42 of the U.S. Code. Same for environmental rules. They're going to show up most of the time in Title 40 of the Code of Federal Regulations. There are outliers. Clean Water Act, Title 33. I think it has something to do with the Corps. I blame it on them. So NEPA is often called the Magna Carta of U.S. environmental law. You probably saw that in the description today. Every article I read had that in the opening paragraph. I had to go look up what it was. The Magna Carta, for those who don't know, is a set of documents issued in the early 1200s that basically put a legal framework around the English monarchy and created common law as we know it today, or bits of it. So likewise, NEPA sort of did the same thing. It created this legal process for transparent environmental review of federal projects, which had not been done before. So it was signed on January 1st, 1970. It was intentional as one of the first things President Nixon did in the new decade. That's the same year EPA was formed. It was also the same year as the first Earth Day. And now it's approaching 50 years old. And And ELI was chartered in 1969 in anticipation of all of the environmental law that was coming along. So since then, approximately half of the states have some version of NEPA. Some have just adopted whole cloth, whatever the feds do, and others have taken it above and beyond. We'll go into that a little bit later. The principles of NEPA have also been exported to over 150 countries, which is pretty amazing. I was telling these guys earlier, I'm actually dealing with environmental impact assessments in China right now. Fun. So NEPA's purpose. This is an interesting statute. In its original form, 3 pages. Clean Air Act amendments of 1990, 800 pages. So it's special, it's poetic, it's even a little bit beautiful. I'm going to read you the purpose. To declare a national policy which will encourage productive and enjoyable harmony between man and his environment, to promote efforts which prevent or eliminate damage to the environment and biosphere, and stimulate the health and welfare of man, to enrich the understanding of the ecological systems and natural resources important to the nation, and to establish a council on environmental quality. They don't write them like that anymore. 7 years later, they didn't write them like that anymore. RCRA was enacted in 1976. It had findings. It starts with findings. Very nice, still useful, not poetic. By the time you get to 1980 with CERCLA, they're like digging in straight into the definitions, like whatever. So read NEPA. It's an interesting read. We won't read all of it today. So here's the framework. There's basically 9 sections that sort of do something. 4331 is the Declaration of National Environmental Policy. It has 6 discrete objectives, all of which apply to federal plans, functions, programs, and resources. 4332 is one of the action-oriented provisions that basically creates the requirement for the EIS. We'll go into that in a little bit more detail later. 4333 directs all of the federal agencies to review their statutes and rules and policies and incorporate NEPA's principles into their own procedures. And 4334 and the subsequent sections establish the Council of Environmental Quality. And you'll notice that these sections don't match the bullets I put on one of the first slides, and that's because at the end, the rest of the sections are under NEPA, but they're more directions to EPA to create certain programs. They're not within that environmental review scope, so we won't cover those today. All right, so the prong we most know is the environmental review prong. It applies to major federal actions significantly affecting the quality of the human environment. And so the courts have spent a lot of time helping us define what a major federal action is. Mostly it's any federal project or federally funded or federally permitted project. So think management activities on federal lands, federal licenses for things like power plants, federal permits for things like publicly owned treatment systems. There are a few exceptions for EPA because they're in the business of environmental protection, but even some of theirs can be subject to it. Importantly, though, US EPA only issues about 95% of the environmental permits in this country. It's really the states at this point, Peg was mentioning with the delegation. Let's see. So the environmental review really just requires a hard look by the agency at what it's doing. And the motto is sort of look before you leap. This statute has lots of unique features. One of them is that it allows for public comment, which we'll get into. Another is that it doesn't actually have an enforcement mechanism. You'll see when we get into the CEQ rules, it creates the CEQ, it gives them some directions, but CEQ does not police this statute. So we've had to turn to the courts for that, and that's where the Administrative Procedure Act kicks in. And a lot of citizen suits have helped define sort of the contours of NEPA beyond what the rules were able to do. Let's see. And so that brings us to another interesting one. It's procedural, not substantive. Environmental law can sort of fall into 2 categories of command and control, which is very much like the statutes Peg was telling us about, right? You will do this, you will not do this, you can only do it this much. And then there's the other side, the sort of conservation side. The Endangered Species Act is a great example of that. And NEPA sort of fits more in that category. It gives a framework, but ultimately it doesn't tell anybody that they have to do something, like it's not going to prescribe the results of the review. It's only going to force the review. let's see. Now, what I mentioned earlier, some of the states that have taken this on have taken it above and beyond, and that's one of the ways they do it. For example, in California, they do require that the adverse impacts be avoided or mitigated. So still not like you choose the most environmentally friendly option, but at least we're pushing there. Another unique factor about the environmental review is that it's only applicable really to the government. It indirectly impacts private actions when they have federal funding or they receive a federal license, but it doesn't actually apply directly to them. It's focused on government management and was sort of intended to let the government provide a sort of a role model or a model for sustainability. Whereas a lot of the command and control in particular focus exclusively and directly on the private sector and then pull in the federal government when it does the same things. Okay. Whoops, I skipped one. So how it works, as I was saying, is that each of the federal agencies implements NEPA through its own rules. Let's take another step back here for those of us who haven't gone to law school. There are statutes enacted by Congress. There are rules promulgated by the federal agencies, and then when that still isn't enough to provide clarity or guidance on what needs to be done, the agencies will issue guidance. And the difference between rules and guidance is that rules are subject to notice and comment rulemaking procedures, right? They have to tell us what they're going to do, they have to let us tell them about what we think about that, and then they have to address those comments. Policy can be issued and withdrawn almost always without any input from the public. So in this case, I'm borrowing from the U.S. Fish and Wildlife Service. This is from their guidance on implementing NEPA, and they put together this very pretty decision-making flowchart, which I thought we could go through sort of quickly. You'll see at the top, and I guess, I don't know if you can see that, but you probably have better eyes than I do. You start with the proposed action at the top, and then it goes into a scoping, and you have to figure out, what are we doing? Does it have an environmental impact? Does it have a significant environmental impact? If there's no significant environmental effects, then it can usually, and usually this is because it fits into one of the categorical exclusions to NEPA, then it can just go straight into implementation. And for example, well, each of the agencies defines what a categorical exclusion is within their paradigm. So examples from Fish and Wildlife are legal activities like arrests and patents, organizational changes, personnel actions, so basically the things that they do behind the scenes that aren't affecting their own lands. Let's see. Right. So on the other extreme, you have a project that you know it's going to have significant environmental effects. This is the line that's going in blue. And so the next phase is a notice of intent, and then sending it out for public scoping, so the public can comment on what it believes might be the environmental impacts. And then it'll go into the draft EIS, more public comment, the final EIS, more public comment, and then finally the record of decision, where the agency or the proponent of the federal action picks the alternative it's going to use, the mitigation efforts it's going to use if needed, and sort of describes the whole thing. And every time there's a public comment option, there's also a response to public comments that the agency will have to issue to address all of those. And then you have that middle lane, which I think happens a lot more frequently. There are 450 environmental impact statements issued usually in a year. There are 45,000 environmental assessments issued in a year, and that's because that's where you sit when you don't know what you got. Right? If you don't know what your environmental impacts are going to be, you do an environmental assessment, and it has the option for public scoping, but it's not required. So once the environmental assessment is done, the proponent of the action can, one, determine whether it has significant environmental impacts, but it also has the option of looking at mitigation at that time. And if the mitigation efforts can pull it back under the threshold for significance, then they can issue a mitigated finding of no significant impact. Otherwise, if the environmental impact assessments just goes, determines that there are no significant environmental impacts, then it's a straight finding of no significant impact. And this was one of my favorite abbreviations of all time, the FONSI. It's left over from my days with Happy Days, but you know. Sounds so happy. Now, sometimes the environmental assessment will demonstrate that there are significant environmental impacts, and then it goes right back into the significant impacts loop and the EIS process. Okay. And then I'll say one thing about the mitigation FONSI or the mitigated FONSI. It's an actionable document, right? It's like a contract. The proponent is committing to perform those mitigation efforts in order to avoid the environmental impacts. And so not only does it force action, but it is also enforceable, which can be handy. All right, so the Council on Environmental Quality. It's modeled after the National Security Council and the Council of Economic Advisors. It sits in the Executive Office of the President. It's got 3 members appointed by the President, confirmed by the Senate. And basically, it serves as an in-house advisor to the President on environmental issues because there are multiple cabinet-level agencies with primary environmental responsibility for multiple programs, but no one coordinating agency. That's what CEQ does, is it sort of gathers up all of that for the president and sort of distills it and advises on those issues. Now, initially, it was directed to issue guidelines, but those guidelines were non-mandatory. They were helpful because 3 pages of statute means we don't have much guidance for like boots on the ground. But after about 7 or so years, they realized that there were excessive delays, excessive paperwork. So President Carter issued a new executive order providing for mandatory guidelines. And when CEQ went back out to issue new guidelines, they also extensively reached out to the stakeholders, the regulated community, the states, the environmental organizations, gathered all of that up, and then issued new rules in 1978. And those have, with the exception of, I think, one amendment in 1986, have not been amended in the past 40 years. So it's a pretty good set of rules. And I'll mention one note about the CEQ. I guess it's not big enough to have its own website. So you can type in NEPA.gov and it will take you to a DOE server. You did not go to the wrong place. That is it. And there's a snippet about the CEQ on the White House website too. Okay, so NEPA today. In February 2018, this year, the White House issued a legislative outline for rebuilding infrastructure in America. And I threw up the link so you can look at it. It's pretty long. It covers more than just NEPA. It covers all of the major statutes too. And we won't go into those today. It's ambitious. It will also be difficult to get all of it done. Some of it requires congressional action. So of course that is a hurdle in and of itself. But if we just focus on the NEPA portion, the goal is really one agency, one decision. The idea is to make it easier for infrastructure to get done. And one of those ways to do that, according to the white paper, is to instruct the CEQ to streamline the NEPA process. And what that looks like in the white paper is a firm deadline of 21 months for the lead agencies to complete their environmental reviews through the issuance of the FONSI or the ROD. And then another deadline of 3 months for the lead agency after the FONSI or the ROD is issued for the whatever other agencies are involved to issue their permits for whatever the project requires. This is huge. I mean, let's go back a second. So basically what we're talking about is everything from the top to the last of the non-red section has to happen within 24 months. Public comments alone, let's say they trim it to the minimum of 30 days. It takes the agency sometimes, what, 2, 3, 5, 6 months to respond to those comments and then publish it again. So these are significant trimmings. It's ambitious. And then also permitting in general, also very difficult. It rarely takes 3 months. Sometimes it takes 3 months just for the agency to be able to know it's got an administratively complete application before we're even talking about technically complete or ready to issue a permit. So very ambitious, but also it trims the it creates a statute of limitations of 150 days after the final agency action, which in most cases is the ROD, sometimes it's the permit. And that's really tight. Now, to be fair, I think CERCLA in California has a 30-day statute of limitations. So it's not impossible, but these things, they're really thick. And when you get to the public comment phase, sometimes you get it all, sometimes there are revisions. You're constantly processing new information. I don't remember when phone books went out, but for those of you who remember what phone books look like, they're monsters. They're huge. They're reams and reams of paper. And so that's a lot to process in 5 months. So we'll see how this goes, right? Technically, CEQ has the ability. It can issue its own rules. Those rules will go through public notice and comment, and we'll have to see what comes out of that. But this is a really ambitious process, and may end up triggering more litigation, but because the negotiations that can't happen before the ROD is issued will have to happen after, and the only way to preserve that is by filing suit within 150 days. And so it may not have the effect of streamlining the process if it just, because once you get into litigation, it can go on forever. But we'll have to see how it goes. And then, of course, there's the other components of the white paper that may require congressional involvement. But anyway, so that is NEPA in a nutshell. I put some resources up here, and there's gobs more out there. Like I said, every agency has its own set of rules and its own, usually its own guidance too. And if you have any questions, you're welcome to, well, hopefully we've left time for questions, and then if not, we'll talk later.
All right. Okay. So now we're gonna find me, and we're gonna talk about the Endangered Species Act. So this is basically an outline of what I'm going to go through in this talk in 20 to 25 minutes. So the great thing about the Endangered Species Act, I mean, it's between NEPA and some of the very detailed statutes that Peg was talking about, it's really short and sweet. I commend it to your attention. These are the major sections. It doesn't take very long to read. Of course, the devil is in the details. But it really is a very short and straightforward, although probably slightly less poetic statute than NEPA. So basically, here's where we are with the Endangered Species Act. As Nikki mentioned, many of the environmental statutes are in 42 USC, 33 USC. Generally, all the wildlife statutes are in 16 USC. So not only the Endangered Species Act, but also a number of the other statutes that I work with, such as the Marine Mammal Protection Act, Migratory Bird Treaty Act, Magna Carta Fisheries Act, that's all 16 USC. And similarly, 50 CFR is the volume of the federal regulations where many, if not most, of the regulations implementing these environmental statutes are found. And just with the statutes itself, the regulations implementing the ESA are also fairly short. So you just really need to go to Part 424, 402, and 17 on a regular basis. The important thing to know about the ESA in terms of its administration is that there's two wildlife agencies, the U.S. Fish and Wildlife Service and NOAA Fisheries, or the National Marine Fisheries Service. Fish and Wildlife Service is an agency within the Department of the Interior, while NOAA Fisheries is an agency within the Department of Commerce. So when you read the ESA, it will refer to the Secretary, meaning either the Secretary of Interior or Commerce, but what it's really referring to is those agencies that have been delegated the authority to implement and manage the statute. And the basic division of responsibility is Fish and Wildlife Service has all terrestrial species, with a few exceptions. They manage their own species. NOAA Fisheries has all marine species, so whether it's fish, marine mammals, even coral species fall under NIMS jurisdiction. One species actually, or set of species that they share jurisdiction over is sea turtles. So there are 7 species of sea turtles in the world. All 7 of them are listed under the ESA. 5 of them occur in U.S. waters. Fish and Wildlife Service has responsibility for sea turtles when they're on nesting beaches. whereas NOAA Fisheries has responsibility while they're in the ocean. But generally speaking, the realms of species that they manage are separate. So let's talk about the purpose and policy of the ESA. As with all of our major federal environmental statutes, these were all enacted back in the 1970s, basically the high watermark of bipartisan cooperation on environmental issues, and it's essentially been downhill ever since. But if you remember, maybe from your history classes, this is a time when we were really becoming aware that humans can have major extinction level impacts on species. I mean, obviously, the passenger pigeon was a bird that numbered in the billions and, ended up as the sole solitary bird in a zoo dying in the 1920s. So, even several decades before the ESA, we were sort of getting a clue that humans it's entirely possible for us to wipe out endangered species. But in the 1970s, the early 70s, this was following on an era when Rachel Carson had published her seminal work called Silent Spring, which was about the impacts of, organic, meaning carbon-based pesticides on, our iconic species like the bald eagle, which was declining to the point of extinction. And so, as part of this high water movement of conservation and environmental law, the Endangered Species Act was enacted in its current form in 1973 to accomplish not only the preservation of individual species, but also recognizing that species cannot exist in a vacuum. So we have to conserve the ecosystems, the habitats that these species depend on for their very existence. And a third purpose that I'll throw out here, as you may know, is that, we are party to a number of international treaties, but most treaties are not self-executing. They have to have a domestic law in order to make them the law of the United States. So the ESA serves that role as an implementing statute for several of the international treaties to which we belong, and I will discuss that down below when we get to Section 8. Another important aspect of the ESA is that it may be a short and sweet statute, but it affects basically every federal agency in the United States. There was a direct an explicit policy to make it the obligation of every federal agency to conserve endangered and threatened species. So, this was pretty revolutionary because, previously the Federal Highways Administration, its job was to build highways, and something like the Bureau of Land Management, its job was to manage federal lands. But with the ESA, the new directive that Congress gave to every federal agency was you have to make conservation of endangered and threatened species a co-equal objective with all the other things that Congress has directed you to do by statute. The key term in here with this conserve or conservation, this is the linchpin around which the ESA revolves, and that is that this is not just a statute that is meant to put species in the emergency room and then maintain them on life support. The entire goal of the statute is not only to prevent species from becoming extinct, but to recover them to the point at which the protections of the statute are no longer needed. So, this is a very ambitious goal. We're not going to just preserve species, but we're going to recover them to the point where they're no longer endangered or threatened. So let's start with Section 4, because this is how species get on the list of endangered or threatened in the first place. So the statute defines what an endangered species is. It's in danger of extinction throughout all or a significant portion of its range. And if it's threatened, it's likely to become endangered within the foreseeable future. So again, if you've gone to law school, you've taken any kind of legal class, then you know that there's a lot of words in here that the devil's going to be in the details, because there's a lot of terms and phrases within these statutory definitions that Congress said, clearly this is important, but we're not going to tell you exactly, what does, for example, foreseeable future mean? What does, for example, a significant portion of its range mean? So, the agencies have had a number of iterations of regulations attempting or policies attempting to define some of these terms, but these are pretty much the lawyer's full employment act, kinds of definitions, because there's always a constant question from various stakeholders as to whether the agencies have gotten any of these definitions right. But what we do know, what Congress did give very clear instructions on, is the time frame on how and when a species gets listed. So there's two different ways a species can start the process of getting on the list. The agencies can list a species and undertake that listing process on their own initiative. But also there's a petition process. So, any person can petition either agency to consider whether a species warrants listing. And Congress established mandatory non-discretionary deadlines for this petition process. So Congress didn't say, here's what you will have to do as a matter of substance with respect to any particular petition, but whatever you do, you have to make your findings on a particular time frame. So the clock starts when a petition is submitted. The agency has 90 days to make a 90-day finding, although that is caveated, essentially it's a practicability. You have 90 days, agency, if you can do it within, your budgetary constraints. And all that 90-day finding process does is say, with the information in the petition and the information we have in our files, before we start going outside of that universe of information, we're not going to start Googling or talking to experts, would a reasonable person believe that the petition action is warranted? And if the answer to that is yes, then the agency starts a status review. So that's when they go to the scientific literature. That's when they go to the experts. That's when they go to the states and they say, what can you tell us about where this species is, what threats it faces, does it warrant listing? And then at the 12-month stage, which is from the time the petition is submitted, they have to answer the question, is the petitioned action warranted? Does it warrant listing as threatened or endangered? If the answer is yes, then they publish a proposed rule that goes into the Federal Register. Interested parties have a certain amount of time to comment on that finding, and then if the answer is no, then the process is over, and that's a final reviewable agency action. But if the answer is yes, and they publish a proposed rule, then there's another 12 months built into the time frame in order to get to the final determination. So based on all the information we have, based on all the comments, do we list or do we not list? If the answer is yes, you get a final listing, and the species go onto the list of endangered or threatened species. It is entirely possible that the answer can be no, and that the proposed rule may be withdrawn. Maybe we found out based on further research that there's this, pocket of individuals we didn't know about, so the species isn't really endangered. Maybe states and private parties have gotten together and they've scrambled to put together conservation agreements so that we have sufficient assurances that the species will be preserved into the future, so it doesn't currently meet the definition of endangered or threatened. So that's the process for getting the species on the list. And what the agencies have to consider, Congress also spelled out. These are the 5 listing factors. And the important thing to know about these is that the agency has to determine whether a species warrants listing based on a single factor or a combination of any of these factors. And there's no weighting given to it in the statute. So, although certainly it's true that many species are imperiled because of habitat destruction is not more important than disease or predation or more important than overutilization. So basically it's left to the agency's expert judgment based on the best available scientific data as to what factor or combination of these factors should result in the decision. It is really important to understand that economic impacts cannot be taken into account at the listing stage. So Congress has specified that the only information that can be taken into account is the best scientific and commercial data available. And that's a really important phrase because it doesn't mean perfect data. Essentially, the Congress determined the perfect should not be the enemy of the good. The agency doesn't have to go out and conduct studies and determine, you know, is a species endangered? It basically has to do a survey, and it can look at anecdotal data. It can look at scientific studies. It can look at individual reports. You know, it has the discretion to essentially weigh and balance all of the available information before it. But because it is meant to be conservation oriented, there was an explicit recognition that we can't wait until we have, you know, perfect peer-reviewed papers on everything before we make listing decisions. It's also important to know that a listing process takes into consideration not only biological information, but also legal information. What are the existing regulatory mechanisms? If this, for example, is a shark species, and National Marine Fisheries Service already has regulations regarding directed catch or bycatch of this shark species under the Magna Act, that's important information to take into consideration because it plays into, you know, are our existing laws and regulations sufficient? And it's the same is true. We have to consider the efforts of state and foreign governments. And because the ESA allows the listing of species that are entirely overseas with, you know, no nexus with US law at all, that is a place where foreign governments will say, you know, you should not list our species because we're already doing these things. We'll get into this when we talk about Section 9. The important distinction from a legal perspective between endangered or threatened species is not only like how endangered are they? Are they endangered right now, or will they become so in the future? But what levels of statutory protections attach? Endangered species automatically get all the protections of the statute. Threatened species automatically get none of the protections of the statute. And the section 4D allows the Secretary to issue regulations necessary and advisable to provide for the conservation of the species, and may by regulation apply Section 9 prohibitions. And for the lawyers, you will know there's a very important difference between shall and may. But this is actually an area that has not been litigated to the extent that I can give you, you know, clear guidance on when the Secretary has to do 4D rules versus when he or she doesn't. Section 4, besides the listing process, also has a very important process for designating critical habitat. So when the Secretary lists a species as endangered or threatened, there's also an obligation contemporaneous with that final listing rule to designate critical habitat. Now, critical habitat can be occupied, in other words, the species is currently found there, or it can be unoccupied, you know, and you can think, you know, it makes sense that species, especially that have faced a tremendous amount of range contraction because of habitat loss, overexploitation, et cetera, maybe they used to exist in a certain place and now they don't anymore. But in order to get them to the point not only of survival, but also recovery, maybe some of that unoccupied critical habitat needs to be designated in order to eventually allow that recovery to occur. So one exception for the obligation to designate critical habitat is if the Secretary determines it's not prudent. And examples where the agencies have determined it's not prudent is, say, example, you have a butterfly and it's only found in one place. And if you go X marks the spot on the map, this is where that butterfly is found. You know, Joe Smith, the butterfly collector, is going to know exactly where to go to get the last of the species for his butterfly collection, or plants, you know, things that have a very limited range or can't run away. Sometimes the secretaries will determine that critical habitat is not prudent because the risks of designation would outweigh the benefits. Even though we can list species overseas, essentially because we, you know, have no leverage over critical habitat in other countries, we don't designate critical habitat outside of US jurisdiction. The other important thing is, you'll recall that I mentioned that economic impacts cannot be taken into account in a listing decision Conversely, economic impacts can be taken into account in a critical habitat designation. So the Secretary, after considering, as per the statute and statutory and regulatory factors, what constitutes critical habitat, can determine that, we will exclude some of these areas from the designation because the economic impacts of designation may outweigh the benefits. So this is where economics can come back into a listing decision. Section 4 also requires recovery plans. These are not mandatory documents, but they're essentially a planning process that says, here's how we need to get to recovery. Here's the goalposts, how we know we will get to a point where endangered species can be downlisted to threatened, and threatened species can be downlisted to not listed at all. And there also needs to be a status review every 5 years so that we can determine, has the species gotten worse? So maybe it needs to be uplisted from threatened to endangered. Is it the same? Has it gotten better? So it might warrant delisting. So, these listing statuses are not set in stone. I'll also mention that just as citizens can petition to list species, citizens can also petition to downlist or delist species, and that happens on a fairly frequent basis. For example, last year, the Fish and Wildlife Service downlisted the West Indian manatee from endangered to threatened, and that was on the basis of a petition process that had been initiated by a citizen petition. So Section 9 is what happens when a species is listed. What kinds of things can you not do to a listed species or its habitat? And I'm going to focus here only on animals and not plants, because plants have their own special rules. But essentially, the answer is you can't do anything to an endangered species of animal, because you cannot harass, harm, hunt, shoot, wound, kill, trap, capture, or collect, or getting back to the intent to engage in any such activity. And by regulation, and this is where a lot of the more impactful actions come in, is a harm has been defined by regulation to include habitat modification, where it actually kills or injures wildlife. So this gets beyond, you can't go out and shoot, for example, a grizzly bear, but you also can't go into its habitat and start modifying that habitat by building a shopping mall or whatever it is, if you're, building it in territory where that habitat modification is going to cause injury to the wildlife. And there are both civil and criminal penalties attached to the statute. And of course, as with, those are civil and criminal penalties that the government can seek against people who violate Section 9. But I really want to spend some time on Section 7, because this is getting back to that nexus with all federal agencies. When Congress told all federal agencies that they have an obligation to conserve listed species, Section 7 is what implements that obligation. 71 says that federal agencies have an obligation to utilize their authorities to carry out programs for the conservation of species. So whether it's federal highways or FDA or any agency you can think of, they're obligated to do something good for species. Now, the courts have found that they don't have to do something good for every species, and that citizen groups cannot come in and try to direct the use of those authorities. They have the discretion to determine how best to use their authorities for endangered species conservation, and the courts are not going to disturb it as long as they're doing something. 782, however, is really where the action is, because every federal agency is obligated to avoid any action that it authorizes, funds, or carries out. It has to avoid jeopardy to the continued existence of the species, or destruction or adverse modification of critical habitat. So if federal highways is going to fund a state highway expansion, if there is an endangered species or threatened species in the path of that highway expansion, then they're going to have to follow Section 7. The important thing to point out here too is we talked about the take prohibitions are different, or by statute, endangered species get all of them, threatened species get none of them. That distinction goes away when it comes to Section 7. So federal agencies are equally obligated to avoid jeopardy to both endangered and threatened species. The seminal case, again, kind of the high watermark of Endangered Species Act litigation, was in 1978 with the case that ended up in the Supreme Court, captioned Tennessee Valley Authority versus Hill, where essentially the Tellico Dam which was intended to provide power for a Boeing plant, was almost done. I mean, they literally just had to do like, one or two more things. And this is actually a project that was hard fought because, it ended up taking a lot of private land. There were a lot of other big issues in this case, or in this, issue, like matter more broadly conceived. But almost at the 11th hour, they discovered this like little 2-inch fish called the snail darter, which, if you've heard of charismatic megafauna, then the snail darter is uncharismatic microfauna. I mean, it's you wouldn't give this fish a second look if you saw it in an aquarium store. But they found the snail darter that required essentially a free-flowing shallow river, and shutting the floodgates on the Tellico Dam to make this reservoir to generate power would completely wipe out the species. So this case went all the way up to the Supreme Court, and it was essentially the Supreme Court told Congress, yeah, this is actually what you did in the statute. Like when you said that all federal agencies have this obligation to halt the trend towards jeopardy at whatever the cost, and when Congress, you said that this now has to be a co-equal mission with your other authorities, that's what you meant, and we're going to hold you to it, which I think was probably a shock to many members in Congress. But this language from TVA v. Hill says this is what Congress intended to do to give endangered species priority over the primary missions of federal agencies. So let's talk about this priority obligation, which is no jeopardy. So the agency obligation is to avoid jeopardizing the survival and recovery of species in the wild, or to avoid destroying or adversely modifying critical habitat. The way that the agency has to meet this substantive obligation to avoid jeopardy and to refrain from destroying or adversely modifying critical habitat is through the process of ESA Section 7 consultation. So just very broadly speaking, I said that an agency action is very broadly defined, but there is a limitation. The action, there has to be some element of discretionary control. The agency has to be able to do good things or avoid doing bad things to the species as part of this action. And this case citation of National Association of Home Builders versus Defenders was a Supreme Court case in 2007 that defined that limit. Then where the agency has no discretion to act, then there is no Section 7 obligation. So that case arose actually in the Clean Water Act context, when EPA was in the process under the Clean Water Act of determining whether to approve or disapprove Arizona's state program to implement the Clean Water Act. And basically what the Supreme Court said there is, like, essentially Congress specified in the Clean Water Act that a delegated program is going to get approved if it meets, the checklist that's defined by statute. And so all EPA's job is to do is go down and check off that checklist. And if the state program meets that checklist, then EPA has no discretionary authority to condition that approval on, oh, by the way, you also have to do good things for species. So that is a kind of example where the federal agency has to follow a checklist and can't deviate from that checklist. It doesn't have a Section 7 obligation. It's important to note that an action area is not only, you're paving the parking lot in Paradise over grizzly bear habitat, but you also have to look at, well, when you're building that parking lot, are you going to have indirect effects because grizzly bears, don't want to be anywhere near humans or something like that. So you have to look at not only like the immediate area of your action, but the wider area as well, to look at the indirect effects that your action could have. Again, a geographic limitation. We can only do things in the U.S., under U.S. law, to federal agency actions that we have control over. So I will not go any further on this, except to note that this slide says essentially where federal agencies, for example, USAID, are building projects overseas, there is no Section 7 obligation there, which is what the Defenders of Wildlife v. Lujan case found. So this is my tiny little flow chart. The consultation process starts with an obligation on the action agency, which is whichever the federal agency is that's taking the action. Are we going to not have an effect on species, or is there a may affect species? If there's no effect, the wildlife agency, the services never get involved. but if there's a may affect determination, then they have to go into what's called informal consultation. Informal consultation is basically just whatever communications there are between the action agency and the wildlife agency. It can be letters, it can be emails, it can be phone calls. It's exactly what it says. It's informal consultation. And if they, during this informal consultation process, determine that the project may affect but is not likely to adversely affect the listed species, then the project goes forward. We're done. If there is a likely to adversely affect determination, or the action agency says, nope, it's not likely to adversely affect, and the service says, nope, you're wrong, then they have to go to formal consultation. And this is where you get a very prescribed set of documents. So on the action agency side, the action agency has to use all the best available scientific data and come up with, here's the effects of the action, the both direct and indirect, here's the baseline of where the species is, here's what our action is going to do, here's cumulative effects of like non-federal projects on the species. So this is the snapshot of how our action affects the species and how that fits into the larger context of where the species status currently is. And then the wildlife agency takes that biological assessment or evaluation, again, has to use all the best available scientific data, and it comes up with a biological opinion as to whether the agency action is going to result in jeopardy or not. If it's a no jeopardy finding, no adverse modification, no destruction of critical habitat, then essentially there's a permit issued, which is in this context called an incidental take statement. You may take, which is otherwise prohibited by Section 9, incidental to this action. In other words, it's not the intent of the action to take the species. And the statement says how much of that incidental take you're allowed to have before we have to go back to the drawing board. You have to minimize the impacts of incidental take through reasonable and prudent measures. You have terms and conditions, including reporting requirements, which is very important, so we understand what the tally is. And if you get above whatever that level set for incidental take, then we have to go back to the drawing board and have a reinitiation of consultation. And the flip side, if the wildlife agency determines that there's jeopardy, then they have to prescribe reasonable and prudent alternatives that would avoid jeopardy. So you can build your highway, but maybe you have to change your alignment so you're going around the endangered species and you're not going to affect it. Something that's important to understand about a biological opinion is it is truly that. It is just an opinion. The action agency has discretion when it receives the biological opinion to choose what to do with it. It can go ahead and implement the BIOP, in which case it's covered by the incidental take statement. It can say, you know what, we have to go back to the drawing board. It can abandon the project, or it can just go its own way and take its chances in subsequent litigation if it chooses not to comply with whatever the opinion has set out. Or it can apply to the God Squad, which is what Congress added to the ESA after the Supreme Court told them in TVA versus Hill what they had done in terms of enacting the statute. And essentially the God Squad is a cabinet level panel that on a vote of 5-2 can say, well, screw the snail darter. We're going to go ahead. We put too much money into the Tellico Dam. We're going to go ahead and close it. And, so long, Charlie, to the endangered species. The God Squad, seems like the big guns, but it's only ever been convened 3 times. So it seems a lot more of a dramatic denouement to a Section 7 issue than it really is. So it's important to understand that, much like in the NEPA context where we have, categorical exclusions and environmental assessments, really, and FONSI's taking up like the bulk of the work, informal consultations are the vast majority of all consultations. This chart is a little bit out of date, but the numbers haven't, the proportions haven't changed. Most consultations end in an informal consultation. The other thing to understand is that the ESA, it certainly has been a favorite target of people who assert that it's constantly stopping projects, but that's actually not what the data bears out. colleagues of mine at the at Defenders of Wildlife actually studied all 81,000 plus consultations that the Fish and Wildlife Service undertook, and found that a maximum of 0 were actually stopped for endangered species, and most of them went forward without any major modifications whatsoever. So this is the study I referred to, which was published back in 2015. But breaking it down into the terms under the statute, if you look at the jeopardy column, you can see, especially since 1991, a decreasing trend in jeopardy opinions. And I think what that really reflects is, well, number one, the wildlife agencies are much more reluctant to issue jeopardy opinions than they may have been once upon a time. But number two, there may be a reduced need for jeopardy opinions because agencies are much more sophisticated and aware now of the needs of species, and the impacts to projects can be negotiated and mitigated up front before you ever get to the back end of needing a jeopardy opinion. And there's no way to know, which of those accounts for the reasons for all the no jeopardy opinions. But it certainly is the case that there's a lot of back and forth trying to, between the Wildlife Agency and the Action Agency, trying to figure out a different way to accomplish the same objective without getting to the jeopardy point. Very briefly, if there's no federal nexus, if you don't need, for example, your Army Corps dredge and fill permit or your Clean Water NPDES permit, you're just a private landowner, you're working on private land and you don't need any federal permits whatsoever, you can also get an incidental take permit under the statute. And you have to put together a habitat conservation plan. And that action of approving the incidental take permit is going to be an action by the wildlife agency, so it has to engage in intra-agency consultation. It has to do NEPA, but at the end of the day, if all that goes forward, then a private landowner or, for example, like a state forestry agency can get coverage under the Endangered Species Act, so it's not liable for any incidental take as long as it has this appropriate permitting. So there's also other kinds of permits. One I really wanted to call out here because it ties into a recent development case is that Section 10 also allows for scientific permits or permits to enhance survival and propagation. One area that Defenders has worked on a lot because of our focus on wolves is so-called Section 10J rules. And these are rules for, we have a captive bred population. We have Mexican gray wolves or red wolves or California condors or whatever it is, and we're breeding them in a captive facility because they're going down the tubes in the wild. But Section 10J establishes mechanisms for how do we then take those captive bred animals and reintroduce them into the wild. So there's rules around that in the Endangered Species Act. Judicial review, I will only quickly mention that there's actually 2 different ways to have a lawsuit under the Endangered Species Act. There's a very broad citizen suit provision, which enables anybody to file a suit against any person, and as Peg mentioned, that's basically everybody. So including federal agencies, state agencies, as long as you get around the 11th Amendment, private parties, if there's a violation of, say, Section 9 or Section 7. And there's also an ability to sue the Secretary under Section 4 relating to listing decisions. But the Supreme Court found in a very important case called Bennett v. Speer in 1997 that the ESA citizen suit does not provide a mechanism to review actions by the wildlife agency. So, for example, if you have a Section 7 case, you can have a Section 7 case that's a citizen suit against the action agency for failure to consult or failure to avoid jeopardy. But if you're going to challenge the wildlife agency's biological opinion, that is an APA suit. So that implicates whether you have to give notice, the kinds of relief that are available, et cetera. Very briefly, I mentioned that the ESA implements our international obligations, including CITES, the Convention on International Trade of Endangered Species of Plants and Animals. And that's extremely important because the US is the world's essentially second largest consumer of wildlife and wildlife products. So because of that huge demand, the ESA implements CITES, which essentially sets up a permitting system for when species can be imported into this country. We are running out of time, so I'm just going to skip over this. This again goes to the importance of the ESA in regulating not only domestic behavior, but commerce into and out of the United States. So let's talk about hot topics on the ESA. And the first one is that for a number of years now, but especially in the last two Congresses, the ESA has become essentially punching bag number one for those who claim that either it stops development, particular species, we're not gonna want you to list them because of the impacts that we fear on whatever our particular industries might be. So these two links, Defenders has tracked each and every legislative attack that's been introduced into the last two Congresses, and some of them, they can range from like a complete rewrite of the statute to a particular directive, like you must delist gray wolves, or you may not list the northern long-eared bat, or whatever it is. But the fact of the matter is that the Endangered Species Act has been chronically underfunded for a number of years, and Congress has actually stepped in and directed that, for example, a huge amount of money goes to conserving listed salmonid species in the Pacific Northwest. So, the amount of money that's available for listed species that aren't these salmon, 80% of all listed species get less than 5% of the funding that's available. So from our perspective, it's not that the ESA is fundamentally broken, it's that Congress has been, deliberately starving it of financial resources. Administrative attacks, I won't go into political appointees and judicial nominees, except to say that, the administrations do matter in terms of who they appoint at the wildlife agencies, at the other agencies, and obviously to the courts. But we are aware that there is a suite of proposed regulations coming down the pike. One of them is going to be from the U.S. Fish and Wildlife Service. I had mentioned earlier that the statute gives no automatic protections to threatened species. Fish and Wildlife Service, a number of years ago, implemented a blanket 4D rule, basically to say that all threatened species by default will get all the protections of Section 9 unless we do a species-specific 4D rule saying otherwise. NIMS has never had that rule, so for NIMS, threatened species have to get a species-specific 4D rule, but Fish and Wildlife Service is going to be proposing to roll back that blanket 4D rule, which will not affect, as we understand it, species that are currently listed as threatened and benefit from that blanket rule, but it will be prospective, so that when Fish and Wildlife Service lists a threatened species, it will be like the situation with NIMS. It will not get any automatic protections unless there's a specific rule. And we also anticipate that there are going to be joint proposed regulations coming out from both the wildlife agencies affecting how Section 7 consultations and Section 4 listings are done, but those are not out yet, so we don't have full details. I also just wanted to throw up some hot topics in litigation, including one that's up at the Supreme Court right now, in which the question of unoccupied versus occupied critical habitat is at stake. And in this Weyerhaeuser case, the petitioners in that case are saying, we've got, you've designated unoccupied critical habitat on our land. There aren't any dusky gopher frogs there. There's never going to be any dusky gopher frogs there. Again, we don't have to do anything good for, species anyway, because it's private land, and critical habitat is really just something that comes into play in the Section 7 consultation process. And so the Supreme Court will be determining what occupied versus unoccupied critical habitat means in the statute, and whose view of the world, either the petitioners or the Fish and Wildlife Services, is correct. Also, going way back to the definitions, the significant portion of range issue has been in litigation pretty much since forever. There have been multiple iterations of policy on significant portion of range. These 3 cases listed here are various facial challenges to that policy. So of course that has huge implications for which species get listed and where. And finally, I mentioned the Mexican wolf 10J rule. This last case on here was a multi-party challenge to a rule that the service promulgated to set directives and limitations around where and when we're going to reintroduce Mexican gray wolves into the wild, and what can happen if, for example, you're a rancher and there's the Mexican gray wolf, can you shoot it or not? So that rule was recently overturned in March of this year because the district court found that it did not do an adequate job on considering, is this population essential or not essential, and it did not do an adequate job in determining whether the rule would advance the conservation, i.e. survival and recovery of the species. So, I know we're rushing through this, but these slides are available to anyone who wants to go look up the citations. And I've also put up a bunch of hyperlinks to resources for understanding not only the ESA from the statutory and regulatory perspective, but also, as both Peg and Nikki mentioned, policies and guidance are critical to understanding how the ESA is implemented. And of these 2 books that I list here, the second one is basically the Cliff Note version to the ESA. So, that's one I always recommend that people start with for a basic primer on the ESA. Even though it's a little bit out of date at this point, it's still a really helpful resource. So I know that took a long time, so we have 10 minutes for questions. Caitlin, how do you want to?
Yeah, we'll start by taking some in the room, and then we do have 1 or 2 online as well. Does anyone have a question here?
And we've stunned everyone into submission.
A lot of information.
Hi, I'm Katie. I'm going into my 3rd year of law school. And first of all, thank you all so much for sharing your time. I'm really impressed that you summed those up in 2 hours. But my question is for Ms. Hill. In the context of Superfunds, to show natural resource damages in a given area, do you have to have baseline data to compare the current condition to, and is that often a limiting factor in those cases?
It wouldn't be a factor to eliminate it. I mean, there might be baseline data. DOI, Department of Interior, put out rules in terms of NRD evaluation, and states have their own evaluation. But basically, it's pretty straightforward in terms of what you would think. I mean, if there really are limits on terms of how you can use a particular resource or whether or not that resource is made available to the public, and that would definitely be assessed in terms of the damages. And there's a number of ways they go about it. I mean, I've been involved in a couple of NRD cases. The one big thing about NRD that's really interesting is there's a lot of Superfund settlements that have not included NRD damages. So there's always this fear by parties that have settled out that you may have DOJ or EPA come calling, or the state, on your door and say, by the way, we've now determined years later that there's NRD. Yeah.
I'll just add to that. I mean, the way I think of natural resource damages is it's almost like the trustee is charging rent for the use.
Right.
So it's not even about how much was used necessarily or where. It's just you used it, you'll pay for it.
Hi, this question is for Jane. I was wondering if you knew about if there's anything in the Senate Farm Bill that's going to impact the ESA.
There is, and quite honestly, I have not had the bandwidth to follow in detail. That's been the task of our government relations department. So if you go on our website, you can certainly see our action alerts and news releases and so forth about the Farm Bill, but that, more generally, Peg mentioned FIFRA, which is the statute that under which EPA registers pesticides, which can obviously have effects on a huge number of listed species, and that the issue of how EPA conducts ESA Section 7 consultations has been a long-standing area of friction. But more generally, because the Farm Bill has such huge impacts on land use, there's a lot of opportunities for both good things to happen for endangered species as well as mischief. But unfortunately, it's such a huge topic off on its own that I just don't deal with it.
Great, Jane. We'll take one from the web also for you. Could you briefly discuss the standard for reinitiation of Section 7 consultation?
Sure. So there's, by regulation, there, do I go up to go back? Yeah, there we go. Dun, 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 dun. So, nope. There we go. So 50 CFR 402.16. Number one, you still have to have discretionary involvement or control. So if it's a wholly passed action and, incidental take limits have been exceeded, but there's nothing more that the federal agency can do, there's no ongoing federal agency action, then there's no duty to reinitiate. But if the agency still has discretionary involvement or control, such that, again, it can, condition whatever's going on the ground for the benefit or the non-detriment of listed species, then number one, if you've exceeded your take limit, then you have to reinitiate consultation. But you can also have new information, like the action is affecting species in a way that we didn't previously know about, or you're modifying your action. So then you have to go back to the reinitiation, or in your action area, there's been new species listed or new critical habitat designated. So any one of those four conditions can trigger the obligation on the action agency to reinitiate consultation. And it's important to know that the action agency is always the one with the obligation to avoid jeopardy. The regulation says that the wildlife agency shall request reinitiation of consultation, but that's all the wildlife agency can do is say, hello, you really should come back and talk to us. The ongoing substantive duty to avoid jeopardy or destruction or adverse modification is always on the action agency through the end of the project, at which point there is no more discretionary involvement or control.
Thank you. I think we have time for one more question in the room.
I was wondering if any of you could comment on the current status of the waters of the United States redefinition.
Yeah, I wouldn't even begin to go there.
Maybe
Very, very complicated.
Yeah, I mean, I think there's another case either coming or they've got it right now, right? I mean, it's
Right, they do have it now, yeah.
they're still
Yeah.
working it out, and every decision leads to more questions. So I think it's highly unlikely we're going to get a solid ruling that says, oh, this is what WOTUS is now
out.
and forever.
Right.
if you can wait 2 weeks, we'll cover it in the Clean Water Act session of summer school.
Oh, great.
It's really detailed, so you kind of have to tie it all together.
I think maybe we do have time for one last question.
Can one of you address the interplay of the different statutes that you talked about? It seems like if there's any federal action under NEPA, you're going to have to consider everything that everybody else talked about, but could somebody address that?
Yeah, so I can start and y'all can pitch in. And that's sort of what it's meant to do, right, is look at the environment and look at the NEPA is meant to force everybody to look at the environmental consequences of the project. And depending on what that project is, it can pull in any number of things. And the idea is let's look at them all at once and figure out what we can do. And that's part of what the streamlining initiative is with the 2018 white paper, is to get the agencies to even start thinking early about what permits are going to be required and how they're going to issue those permits and what limits or what constraints.
So, the impacts on endangered or threatened species is one of the 10 factors that agencies have to consider in determining whether an action is significant, thus triggering an EIS. Although interestingly, there's case law that says that the significance of the impact goes above and beyond jeopardy. So the agency cannot just stop at a biological opinion and say, okay, we're done for NEPA purposes, there's no jeopardy, so there's no significant impacts. But I think this is where all three of it comes together. If PEG has a client and they need a NPDES permit under the Clean Water Act, from the federal agency, not from the state agency. So let's pretend it's in a state that doesn't have a delegated program, then that client has to go to EPA for the permit. EPA has to say, well, maybe there's a listed mussel in my stream, so now I have to determine, are the impacts of this discharge going to, where are we going to be on the flow chart? Like not no effect, may affect, not likely to adversely affect, or likely to adversely affect, and now we have to go do a consultation, because before EPA can issue that NPDES permit, it has to have coverage so that its issuance of that permit does not get to the jeopardy. And then, depending on what the federal statute is, it may also trigger NEPA review. And you can get into, a lot of federal permits going on, and the procedural review of NEPA, the substantive obligations of the ESA, this is where it all comes together.
Yeah, I'm just thinking out loud here to myself that probably one of the biggest ongoing project developments that's occurring in certain parts of the U.S. right now are pipeline developments, and I know because I'm working on them. But pipelines, by their nature, because they're traversing across a lot of land, could require, NPDES permits. It could require, depending on the types of supporting facilities, could require a Clean Air Act permit. Also might involve, hazardous waste issues, but at the same time could ultimately involve, for example, the need to have an EIS or an environmental assessment, because there might be some federal permit, like, the Corps of Engineers, for example, or it might be that first involved, for example, with natural gas, so that it does require NEPA review. And of course, on any type of pipeline permit project, you're going to get involved with the ESA. And you're not going to just get involved at, the federal level. It's going to involve the state, it's going to involve historic resources as well. So it could involve also the preservation of historical resources, in addition to preservation of endangered species or threatened species.
Or you may cross federal land, and so then you need, whatever approvals from whatever federal agencies are managing that land. So.
Thank you. I think our panelists will be here for another minute when we conclude. So if you have any burning questions, they might be able to help you still. So thank you so much to our in-person and online audiences for joining us today and for your great questions. We hope you'll continue to think about and learn about NEPA, ESA, and the fundamentals of environmental law. You can stay up to date with our summer school series on our website, eli.org, and next Tuesday we'll be diving into land use law. Sign up today. An enormous thank you to our fantastic panel. Peg, Nikki, and Jane, you and your vast knowledge on these topics has been fascinating, and we're so grateful you joined us today. Thank you.
Thank you.
Thank you.